Well, hello, ladies and gentlemen. Good afternoon, distinguished guests. I'm using a roving mic because I prefer to be able to move around a little bit when I'm speaking. I'd like to first of all thank the British Council for facilitating my presence here today at this important conference, and also Transparency International for giving me a slot on the bill to talk about what I think is an important aspect of the fight against corruption. Now, the lunch was very good. I hope you enjoyed it. I didn't have an awful lot of time to eat mine, but I'm a lawyer, so later I'll just go back to my room and drink some blood. Now, today we've heard about much of the important issues that countries need to address when tackling corruption. Much of it we've heard about is the human interest aspect of it. Well, I'm afraid that I might now be about to spoil that because I'm a lawyer and I'm going to talk about legal stuff, but I'll try and make it as engaging as I possibly can. Okay, right, well, let's move on to an outline of what I'm going to talk about today. Fighting corruption requires a multifaceted approach. And we've heard about education, we've heard about culture, influencing culture. And we've heard about incentivizing the business community, all very important. And political will, of course, which is, well, absolutely essential. But key to an effective program to address corruption is enforcement. Without enforcement, there's no deterrent. Yeah? You need to be able to show that people will be prosecuted and will go to prison if they're convicted of bribery and corruption. It's a serious offense. Now, you can enforce bad law. I mean, we enforced bad law in the United Kingdom for quite a few years before we reformed our law. But it's much easier to enforce a law which is modern, inclusive, and streamlined. It gives the police, the prosecutors, and the courts the tools they need to address and tackle bribery in the 21st century, in the digitalized global economy that we now live in. And earlier I heard people discussing whether this was a matter of empowering people or empowering the authorities with a good framework, a good criminal justice system. Well, the fact is that a good legal framework is empowering for the people. A good legal framework will give the people, as an emanation of the people, the courts, the police, etc., the authorities, the tools they need to effectively address bribery and corruption. First of all, I'm going to talk about the international framework a little bit, but not too much, because I don't think these days the international framework, well, I won't comment on that now, but I won't spend too much time on that. I'll talk about how you go about defining an effective set of offenses to tackle bribery. I'll talk about what were the policy drivers in the United Kingdom that encouraged us, motivated us to reform. I'm going to talk about corporate liability. I mean, as Jose was saying later, you know, our focus really needs to be the big cases. The big cases. Now, these cases involve large sums of money, and they're always about business. Yeah? I mean, some people argue that bribery is essentially a matter of business, really, motivated by the search for lucrative contracts, motivated by the pursuit of profit. So I think that any framework that is going to be effective to tackle bribery needs to take on board commercial bribery. And by that I mean it needs to have some form of corporate liability. I'll talk about the key characteristics of the Bribery Act, not in any great detail. I'll talk about the Ministry of Justice guidance for businesses to assist them in putting in place adequate bribery prevention procedures for the purposes of the defense that applies in the United Kingdom law, which I'll come to later. I'll talk about deferred prosecution agreements, which is an idea we borrowed from the United States. We've done it quite a bit differently in the UK. And I'll talk briefly about other elements that there needs to be in an effective legislative framework. Okay, so the international obligations. Well, I'm sure you're familiar with these. Of course, there is the United Nations, there's the Council of Europe, there's the OECD, the EU now has anti-corruption standards, and the Organization of American States, I think that's right, the OAS. My focus now will actually be on the UN Convention Against Corruption and the OECD Convention Against Bribery in international business transactions. Now, actually, the first convention was the OECD convention. Why was that? Well, it was because the United States of America had in place their own legislation to penalize US companies that were paying bribes overseas since the 1970s. And they updated it in the 1990s. And US companies complained to the Department of Commerce and the Department of Justice, look, nobody else is doing this, yeah? And countries are bribing foreign public officials, and so it's not fair, you know, we are losing out here by way of the competition. So the United States, which, as you probably know, has a huge influence in the OECD, because the OECD is an organization that grew out of the money that the United States put into Europe after the Second World War to make sure that communism didn't spread any further west. So we have to give the United States the credit for kicking off this consensus. They persuaded the OECD to set up a bribery working group and to negotiate this convention that deals with bribery bribery of foreign public officials in international business transactions. Now, it's concerned only with active bribery. That's the offering of bribes, the giving of bribes, yeah? It's not concerned with what we call passive bribery. Now, the United Nations Convention is much broader. In fact, the United Nations Convention is properly called a Convention Against Corruption, because corruption is a much broader term than bribery. All bribery is corruption, but not all corruption is bribery. So the UN Convention has a very wide scope. It deals with fraud and theft and misuse of public office, things like that. And the mix of discretionary and mandatory obligations reflects the need to achieve a broad consensus across a huge range of countries. I think there are around 175 state parties. You know, so if you look at it, it does reflect the need for a very broad consensus, and therefore the standard is really not that high. But for me, the heart of it is bribery. And the fact is that the OECD bribery working group and the convention, although it is very narrow in scope, is much more influential in many nations than the United Nations Convention Against Corruption. Now, this leads me to talk about what is the future for the international framework. Many countries comply with the United Nations Convention Against Corruption. They comply with the OECD Convention. But that tells you nothing about what they are doing to actually tackle corruption in their countries. And many people are now beginning to realize that maybe the framework as it is at the moment is more of a hindrance than a help in actively encouraging countries to do something on the ground to fight bribery and corruption. Now, the passage there on scope and terminology, that is really just the terms that are used in the conventions. And you have the nature of the bribe usually described as some sort of undue advantage. You have the nature of the quid pro quo is usually acting or refrain from acting in accordance with duties, something like that. All of the conventions, the UN convention deals with active and passive, but if you take the standards as a whole, if you want to comply with them, you have to have active and passive offenses of bribery. You have to be able to deal with bribery that is done through intermediaries. Basically, all bribery is done through intermediaries, except very low level. You need to be able to deal with bribes that are paid to third-party beneficiaries, because again, that is a very common way that bribery is done. And you need to address bribery in the private sector, and you need to address corporate liability if you're going to reach the standard that is set by these international instruments. Actually, corruption in the private sector does not receive anywhere near the same amount of attention in the international instruments as bribery in the public sector. In fact, in many states, the notion of private-to-private corruption is somewhat alien to their concepts of doing business, right? Most people conceive of bribery as bribery of officials, either by businesses or by individuals. So I think as regards the private sector, in UNCAC, for example, I think those obligations are discretionary. Now, as regards corporate liability, there's no obligation to have criminal law, criminal corporate liability. It can be administrative. Indeed, one of the most effective regimes for corporate liability is the German regime, and that is entirely administrative. If you are looking at inaugurating a new framework of bribery offenses for your country, what do you need to think about? Now, the thing about defining bribery is that, in fact, we all know when we're confronted with a corrupt transaction. You can sense it. It almost has a smell. It smells funny. You don't need to be told that there is something wrong with this transaction. But defining it for the purposes of the criminal law, well, that's not quite so easy. It can be done, of course, but you have to think carefully about what you want to do. And there are quite a few different models around in the world for this, but I'm going to touch on 3 of them that actually are manifest in our UK legislation. So it's easier for me to talk about those. So the agent principal model, in this model, bribery is perceived as inducing an agent to act against the interests of his or her principal. And agent and principal is there, the meaning is in the broadest sense. So anybody that is working for somebody, supposed to be acting in their interests. If you are induced to act against the interests of your principal, of your boss, then that's deemed to be bribery. But it doesn't work well, for example, in the public sector. Because in the public sector, your principal is the public interest. So it's quite difficult to conceive of being induced to act against the public interest. It's easy to conceive in general terms, but it's difficult to conceive with the precision necessary for the criminal law. And also, if the offense is acting against the interests of your principal, if your principal says it's all right, then you've got a defense, yeah? Because you're not acting against the interests of your principal. So that creates obvious potential for abuse. Now, the second one, improper performance, is the one that we've used in the Bribery Act. And we obviously think that is the best one. It's the one that is employed in the general offenses in the Bribery Act. These are the general offenses that deal with active and passive bribery in the public and private sector. And what that is about is that bribery is an advantage, be it pecuniary or otherwise, that induces a person, yeah, to perform a function improperly, be it a public function or a private function. And they will be deemed to have performed the function improperly, or if the conduct in which they engage is a breach of an expectation that they act impartially, that they act in good faith, or they act in accordance with a position of trust that they're in. Now, it's a UK-centric test. We put this in to avoid the situation where UK nationals bribing overseas can say, well, yeah, but the expectations are really low in this place. In fact, they expect to be bribed, so it's not a breach of an expectation. I'm not inducing anybody to breach an expectation. So we made it a UK-centric test. So the test is, would this be a breach of an expectation if it occurred in the United Kingdom? Yeah. So it rules out that loophole that could otherwise arise. Influence. This model really is for active bribery only, offering, promising, giving of bribes. And it means that you give a bribe to somebody in order to influence them in their decision-making as a foreign public official or as a domestic official. It's about undue influence. And this is the model that is reflected in the OECD Bribery Convention. And it's the model that is reflected in the Bribery Act, Section 6, which is the offence of bribing foreign public officials. So, why did we reform in the United Kingdom? Now, the UK wanted to be seen as a leader in the international consensus against corruption. And we'd come under a lot of criticism, principally from the OECD. I don't know how much you know about the OECD Bribery Working Group, but it used to be chaired by a very formidable gentleman, Professor Mark Peat. And he was extremely critical of the United Kingdom law. Actually, not just him, it was obviously the whole Bribery Working Group, but he was a very strong influencer in that environment. And principally, the problem was with our corporate liability. Corporate liability is absolutely, as I mentioned earlier, essential if you're going to address commercial bribery. It's been accepted now, I think, by the business community around the world that bribery is generally bad for business. It creates uncertainty, there's a lack of redress if anything goes wrong, it distorts markets, it's extremely costly. The World Bank reckons that 10% of business costs are bribery, and it inhibits innovation, etc., etc. There are lots of reasons. So this form of bribery, commercial bribery, needs to be addressed, and an important aspect of that is corporate liability. And what we wanted to do was to encourage businesses, to encourage the private sector to play its role in the fight against corruption. Because the fight against corruption will not be won by state action alone. Yeah? You need the collaboration of business if you're going to make a significant impact on levels of corruption as they are at the moment. Now, the last three bullets are just about the process that occurred in the United Kingdom, so I won't go into that. We started the Law Commission, then we went through a pre-legislative scrutiny process, and eventually parliamentary proceedings. Now, further on corporate liability, what's interesting to note, oops, too far. What's interesting to note, I hope you can read that, it's quite small actually, but in some countries, corporate liability is a well-established legal principle, right? The United Kingdom, hence, of course, Trinidad and Tobago, I think, would be where the law, is common law, generally reflects UK principles, but also USA, Canada as well. And there are some civil jurisdictions. I think Netherlands is one to note there. These countries have had corporate liability in their system for a while. But there are many that have just recently developed it. France, actually, which isn't up there, was the first in 1994. But you can see the list there: Italy, Poland, Romania, Luxembourg, etc. And there's even movement now in Germany to have new corporate liability, despite the effectiveness of their administrative scheme. A proposal for criminal corporate liability was introduced into the, in Germany by the North Rhine-Westphalia state. I don't know what actually has happened to that proposal, but it's indicative of a general rise in preference for corporate criminal liability. And, of course, there's the UK, Section 7 failure to prevent liability, which I will talk about, the Ukraine criminal liability. And what these schemes all have in common is that if companies put in place systems and controls, that will be beneficial for them in some way if they come to the attention of prosecutors. Either because in law it will mean that there is no intent on the part of the corporate body to commit offences. It could provide a defence of some kind, as it does in the UK legislation. It could be a mitigating factor in sentencing. And it could even impact on decisions to bring prosecutions in the first place. Penalties, yeah, they tend to be very high these days for corporates convicted of bribery. Fine, obviously, is the most common penalty for a corporate body. You can't send a corporate body to prison. I've actually got some figures here from the DOJ about the top 10 current FCPA, that's the Foreign Corrupt Practices Act, fines. They're quite astonishing. Top is Siemens, a German company, $800 million, 2008. Alstom, French company, $772 million. KBR Halliburton, USA, $579 million. You've got BAE Systems, UK, $400 million. Total, France, $398. Alcoa, US. Sambrighetti, Netherlands, $365. Technip, France, $338. JGC Corporation, Japan, $218. Daimler, Germany, $185 million. Actually, what do you notice about that list of the US top fines levied by the courts? Most of them are foreign companies, right? There's only 2 US companies on that list. And one of the criticisms that is sometimes levied against the United States is that their enforcement policy looks sometimes a little bit like helping US companies reduce competition in international markets. I won't say any more about that. So the Bribery Act. First of all, this is mainstream criminal law. Because you can address bribery, particularly corporate, commercial bribery, through regulatory schemes. But we think it needs to be criminal law, and it needs to attract a serious penalty. It needs to reflect the fact that bribery is not simply an economic crime. As we've heard earlier today, people die as a result of bribery. It's a very, very serious offense. It undermines the principles upon which our democratic institutions are founded. So it ought to be treated, and the public in the UK demand it, as a very serious criminal offense. Now, there's only 4 offenses in the Bribery Act. My main point about this is that it's all-inclusive. You don't need to have a lot of offenses. We've only got 2 general offenses, one for active, one for passive bribery, and it covers all kinds of bribery, yeah? So it's concise, it's straightforward. We have a special offense for bribery of foreign public officials because we wanted to make it absolutely clear to Mark Peet that we did comply with the OECD bribery convention. And there are other reasons as well, which I won't go into now. And we've got the 4th offense is this Section 7 failure to prevent corporate liability. Now, the Section 6 and Section 7 both have a business focus. Yeah? They both require the prosecution to show that there was an intention to obtain business or an advantage in the conduct of business. Now, jurisdiction. In this day and age, bribery, if it's going to be addressed properly, needs to have a lot of international cooperation. And if you're going to engage in that properly, you need to have jurisdiction, extraterritorial jurisdiction, as well as jurisdiction to deal with crimes that occur within your country. And so we introduced that into the Bribery Act. It's interesting to note that, in fact, we have jurisdiction over all UK nationals, which includes British Overseas Territory citizens, which means that a citizen of Bermuda, of TCI, Turks and Caicos Islands, of Cayman or British Virgin Islands, or the Falkland Islands for that matter, even Tristan da Cunha, all these people can be prosecuted in England, in the United Kingdom, for offences which they commit in their own territory. It's quite controversial, actually, within those territories, as you can imagine. So that's one sort of little wrinkle in the jurisdictional provisions that we have in the Act. Moving on quickly, consent to prosecution, that is just about making sure that you don't get ridiculous cases before the courts. So every bribery case has to go before either the Director of Public Prosecutions or the Director of the Serious Fraud Office to make sure that there is a case, that this is a case that is in the public interest to take forward as a prosecution. We've got very robust sanctions, 10 years maximum penalty for individuals, and unlimited fines, So the fine can be as big as the court thinks is appropriate. Now, the Bribery Act has been received internationally very well. It has received a lot of international recognition, principally because it promotes high global standards on commercial bribery. Yeah? And how does it do that? It does that through the corporate failure to prevent liability. So what is that about? This is a form of vicarious liability. So if somebody pays a bribe on behalf of a company, the company is liable. That's it, right? Prima facie liable. There's no need for any knowledge or intention at the corporate center. So that's quite a robust offense. But it's coupled with an equally robust defense. So if the company can show that despite the bribery taking place, it's actually put in place bribery prevention procedures to prevent bribery, then it will have a full defense. So you may think, well, how can the procedures be adequate if bribery has taken place? Well, of course, companies, even the best companies, doing all that they can to prevent bribery, cannot prevent somebody from bribing on their behalf if they're absolutely determined to do so. And it wouldn't be fair to prosecute a company in those circumstances. Lawyers argue about whether this offense is strict liability. We don't need to argue about that today. Of course, bribery overseas always takes place through local agents and business partners, yeah? So UK companies, US companies, French companies, German companies, etc., they're very keen to ensure that their partners, their agents working for them in foreign jurisdictions do not use bribery on their behalf because they stand to be fined quite significantly if this comes to light and prosecutors are interested. And prosecutors are very interested, I can tell you, you know. I mean, the DOJ is the chief, the leader, as you can imagine, in enforcement. But it's not the only one. In the United Kingdom, we've recently prosecuted a company under Section 7, yeah, the Sweet Group. And there was a deferred prosecution agreement, which I'm going to talk about in a minute, with the Standard Bank in respect of corruption in Kenya. So, you know, the likelihood of companies being prosecuted is increasing. Now, what this does is it encourages and supports local initiatives to fight corruption, yeah? Because big business is important to these jurisdictions, yeah? They want companies to come and work there, to take up contracts there. It's in their interests to ensure that companies can act ethically. And there is an emerging business elite that wants the rule of law, that wants level playing fields. And in that respect, actually, we found that the UK companies, they've actually acquired a sort of a ethical guarantee because people know that they have to meet the standards of this quite robust legislation, the Bribery Act. Not too long to go now, I think. Now, Ministry of Justice guidance, what this is, that, because this was new, innovative law the failure to prevent liability, Parliament insisted that we give companies guidance on how they go about putting adequate procedures in place. So it's not the law, it's only guidance. There's no obligations in there. Companies can ignore the Bribery Act altogether. They can say to themselves, well, we're not going to do any adequate procedures. We don't give a damn about the Bribery Act. They're not committing an offense. Yeah? No obligations. It's principle-based. Yeah? So it's not a tick box. It's outcome-focused. The idea is to help companies decide for themselves what would be best for them in the way of bribery prevention procedures. And its proportionality is the biggest principle. So a small business working in low-risk jurisdictions doesn't need very much in the way of procedures to achieve adequacy. A large conglomerate working in a lot of high-risk countries will, in the converse, require something much more sophisticated to achieve the adequacy required by the defense. And the guidance is set out there. There's an explanation of the relevant offenses, the principles with illustrative examples, and factual scenarios. Now, moving on to perhaps the most important aspect, as I mentioned earlier, is enforcement and incentives. As I said earlier, state action alone will not significantly lower levels of corruption. You need to incentivize the private sector to play its role. Of course, enforcement is essential, but it has to be linked with mechanisms that encourage businesses to realize that the short-term gains that they get from bribery are less than the cost of the sanctions and the cost of the bribery itself, plus the incentives to act ethically. So we want to encourage businesses to do this. And one aspect of that is encouraging them to self-refer bribery to the authorities themselves, yeah? Because they know that if they've got procedures in place, the authorities are going to look on this sympathetically, and they may have the defense available. If they don't have the offense, there may be some other way of dealing with the case, a diversion away from prosecution. And until recently, the only diversion away from prosecution in these circumstances was what we call civil recovery. In other words, the company would have to give up the profits that it made, the money that it made from the bribery, but they would not be prosecuted. But now we have deferred prosecution agreements, and the first deferred prosecution agreement, as I mentioned earlier, was agreed in just before Christmas last year with a standard bank. Now, what are deferred prosecution agreements? There's way too much on this slide, but the principal features are, first of all, it's an agreement. Yeah? It's not an adversarial scheme. So the two sides don't go into court and argue about what should be in this agreement. They agree the terms of a DPA, and then they go before the court, and the court is asked to approve it as being in the interest of justice and fair and reasonable in its terms in all the circumstances. It's all about transparency. So unlike the United States, we in the UK decided there has to be a heavy judicial oversight of this process. So in our system, each DPA has to be announced in open court, with civil society there, with the press there. And the terms of the agreement, there are no mandatory terms that have to be in there. They can have virtually anything in there, but it will, of course, have a fine. It will have disgorgement of profits, orders to pay costs, compliance measures, external monitoring of compliance. And interestingly, it will almost invariably require the company to provide evidence upon which individuals, the individuals concerned, can be prosecuted. And one thing I want to say about that is you may recall that Sally Yates, the Deputy Attorney General of the United States, gave a speech. It's called the Yates Memorandum, in which she said that no company will obtain a settlement with the Department of Justice or the SEC, the Security Exchange Commission, unless they will give evidence that will enable the prosecutors to prosecute individuals. And it's pretty much the same position in the United Kingdom. So I'm not going to dwell on this too much. I think you get the general idea. If the company complies with the DPA, then there will be no prosecution. Yeah? The indictment is suspended, and if the company behaves itself for the 2 or 3 years term of the DPA, then that's the end of the matter. If they breach it in a serious way, the indictment can be revitalized, so to speak, and the company can be prosecuted for the original offense. I just want to mention 1 or 2 things about other aspects of a legislative framework which are very important. Some of these have been mentioned already today. There is a need, obviously, for good law of evidence. And there's a need for the authorities to have the right investigative powers. Perhaps there's a need for specialist courts with judges trained, particularly with economic crime cases. There has to be flexible laws of admissibility. You've got to move away from reliance on testimony of witnesses. Bribery cases are not about somebody saying, oh yes, I was there and they definitely handed over $10 million to the Minister of Commerce in Uganda or whatever, yeah? It's not that kind of case. No one leaves emails lying around saying, here's your bribe, you know? It's all about forensic accounting. It's about following the money. It's about making sure that you can put before the jury the paper trail from which the jury can infer that corruption took place. That's how these cases work. So you have to have the framework that allows that to happen. You need, of course, laws which allow you to properly engage internationally through mutual legal assistance, extradition. Asset recovery, absolutely essential. And one important new innovation in that area is the use of not criminal law or civil recovery, which is the obtaining of the proceeds of crime from somebody who actually didn't commit the offense, yeah? Not those, but in fact, use of civil actions to obtain ill-gotten gains. And it's been used very successfully in the Caribbean, actually, by lawyers acting on behalf of governments who want to get back assets that have been obtained illicitly, yeah? Through the use of civil law, the tort of corruption, yeah? And of course you need anti-money money laundering legislation. And you need such things as law that allows you to exclude somebody from public procurement, yeah, should they be prosecuted for a bribery offense. Beneficial ownership. Now, we've moved on this in the UK, I think, as Jose said earlier. It's very important. This is about disrupting the key vehicle for the illicit flow of money, which is companies, yeah? Organized criminals and PEPs, corrupt PEPs, they use companies, yeah, in order to move their money about and to launder it. And if you don't know who owns a company, who is the beneficial of a company, it's much more difficult to identify illicit money that is moving through company accounts. So it's all about disrupting that flow. And of course, it enhances transparency, and transparency is the basis of sound business, as we know. I mean, just, I'm not sure if it was mentioned earlier, but 23 billion, well, between 23 and 57 billion pounds is laundered through the UK every year. You know, that's significant sums. And beneficial ownership, requiring people to give information about who actually owns the business, is a very good way of disrupting that flow. Well, I hope I haven't run over, and I hope that has been interesting. As I said, I went through it at a bit of a canter. There's an awful lot to talk about there. Of course, I will answer any questions that anybody has, and I can remain up here to do that. But my message is that in order to address bribery, to tackle bribery, it's better if you have a clear, modern, streamlined law and procedures. It makes it much easier for prosecutors and the authorities to tackle bribery. And it can be put in place relatively easy if the political will is there. That's their patch. Politicians can pass legislation. That's what they do. Yeah? So if politicians have the will to do that, it's the easiest thing in the world to get a piece of legislation through Parliament. If necessary, as happens in the UK, they can do it overnight. It's not difficult to put a legislative framework in place. Of course, you need to have public consultation, etc. But the point I'm making is if the political will is there, then it's not a difficult task at all. And of course, there will be grey areas. All criminal law is a little bit blurred around the edges, yeah? But only the corrupt have anything to fear in the adoption of the sort of legislative framework that I've been describing today. Well, I do hope that that wasn't too legalese and that it was of some interest. As I said, I probably missed some points because it was a fairly quick canter through. But thank you very much indeed for your time. Thank you very much.